I'm going to show you a straightforward method for determining whether the questioning of a suspect violates the Constitution or other federal law. It should prove a helpful tool for peace officers making decisions as to whether questioning is permissible in current investigations. It also will prove a useful tool for defense attorneys, prosecutors, or judges trying to spot issues in their current cases. We're going to do this using the police interrogation tool on TrialDex. First, a word about TrialDex. TrialDex is a new website. You can access it at trialdex.com. It's absolutely free and comes with a number of interrogation tools, including an index collection of pattern jury instructions, the most comprehensive such collection on the internet. This video is going to use the police interrogation tool, which is accessed from a link on the TrialDex front page. TrialDex tools come in two parts. They are question and answers, that is Q&As, accompanied by a flowchart. Let's begin by looking quickly at the flowchart. You can click on the thumbnail to bring it up full screen. It, I think, effectively illustrates the complexity of the issues involved here. It's a PDF file, and you can, if you like, pause the video and print it out for reference as we go along. The Q&As are going to explore whether statements obtained by law enforcement officers violate federal law. That is, the due process clauses of the 5th and 14th Amendment, the 6th Amendment right to counsel, the right to a speedy arraignment, and the Miranda rule. They further clarify the availability of illegally obtained statements for impeachment and the application of the fruit of the poisonous tree doctrine. Now, some states have provided greater protections for criminal suspects under their constitutions and statutes, but the emphasis here is on settled federal principles resolved by the United States Supreme Court, which tend to set the baseline in state cases as well. Now, every case is different, and depends on how you answer each question will take you on a different path through the Q&As. But following along with what I'm doing here should familiarize yourself with the tool so that you can use it on your case. With that in mind, let's start the Q&As. First, let's take a look at whether the statement is voluntary. Statements are involuntary if they are the product of coercion, that is, the suspect's will was overborne in the totality of the circumstances. Typically, that's going to involve threats or promises made by the police or allegations of tricks or lies by the police. It's important to remember when you're evaluating a voluntariness issue that none of these are per se rules. They don't knock out a confession by themselves. You have to look at the totality of the circumstances, and the confession might be considered voluntary even if there was something that could be construed as a threat or promise or a trick or lie. In this case, let's go ahead and just assume that the statement was voluntarily made in the totality of the circumstances. Now, voluntary statements may nevertheless be inadmissible if they're obtained in violation of the right to counsel. As kind of a preliminary question, let's look at whether the suspect had a lawyer at the time of the questioning. In this case, let's assume that for whatever reason, the suspect had hired a lawyer and had one at the time that the officer was questioning. Interestingly, a law enforcement agent's freedom of action is not significantly impacted by the hiring of an attorney. It doesn't trigger any protections under the 6th Amendment, even if the suspect is the focus of a government investigation. Prosecutors may have ethical constraints here that would prevent them from supervising such questioning, but let's assume there's no prosecutors involved. In that case, there's really nothing to look at here. We have to look elsewhere to determine whether there's an actual 6th Amendment right to counsel issue. So let's click on that selection. Examine whether the 6th Amendment right to counsel is attached for other reasons. Attachment of the 6th Amendment right to counsel takes place if there's been an indictment or an initial appearance on a complaint or information where liberty is subject to restriction. It does not apply to pre-charge questioning, even if the suspect has been arrested. In this fairly typical example of an interrogation, let's just assume that there's been no indictment or initial appearance so far. So we'll click on neither of these things are true. Federal custody may trigger speedy arraignment obligations, and this is largely statutory. Just in our particular case, let's just say it's a typical situation with custody, if any, would be state custody, not federal custody, so that those statutes wouldn't be involved. That means that we'll start looking at the Miranda rule. Miranda rule has a number of elements, one of which is custody. A suspect is in Miranda custody if the relevant environment presents the same inherently coercive pressures as the type of station house questioning at issue in Miranda. For that reason, questioning in the suspect's home is usually not custodial. You may even have non-custodial questioning where the suspect is not technically free to leave. An example for that would be a roadside traffic investigation. Questioning may be non-custodial in the station house, although it typically is, or even in prison, depending on the circumstances. If it's anyway, looking at those cases and those standards, you can answer the question: was it custodial? In this case, let's go ahead and assume that it was in fact custodial. The Miranda rule comes into play where the suspect is subjected to custodial interrogation by law enforcement. Volunteered statements don't qualify. Interrogation means express questioning or its functional equivalent, that is, words that the questioner should know are reasonably likely to elicit an incriminating response. Let's go ahead and say that in this fairly typical case, there was, in fact, questioning by the police officer. Now, even if you have custodial questioning by a peace officer, that doesn't necessarily trigger the Miranda rule. There are some exceptions. One is the routine booking question exception, and the other one is the public safety exception. Typically involves where police ask for whether there's a gun or something like that outweighs the need for the prophylactic Miranda rule. Well, let's just say neither of those are involved, so we'll check the third option here, not booking in or safety questions. Okay, assuming that we have custodial interrogation subject to the Miranda rule, the police are required to read the defendant certain constitutional rights. They're the ones found on the standard Miranda card. The rights do not need to be word for word. Substance, not form, is the test. Let's assume in this case that the suspect was informed of all of the Miranda rights, at least in substance. Now, if during the colloquy with the suspect makes an ambiguous statement regarding the right to remain silent or the right to counsel, it was certainly good police practice to stop and clarify what the suspect means, but police officers are not required to do so. Officers may proceed to interrogate the suspect without asking clarifying questions. If the invocation is unambiguous, however, then certain consequences apply. Let's just say in this particular case that there was no unambiguous invocation of a Miranda right. The government must show a voluntary and intelligent waiver of Miranda rights. So officers will often conclude the warning with a request for an express verbal or written waiver. But an express waiver is not technically required. A waiver can be implied from the circumstances, even in circumstances where the suspect, for example, refuses to sign the rights card. The voluntariness of a Miranda waiver is analyzed much the same as the voluntariness of the statement. Once again, the totality of the circumstances is critical. Okay, let's say that the waiver of Miranda rights was voluntary in the totality of the circumstances. An intelligent waiver is the second part of a waiver. It has to be both voluntary and intelligent. It does not require a sophisticated understanding of things or the knowledge of all of the relevant circumstances. It is intelligent if it's made with full awareness of both the nature of the right being abandoned and the consequences of the decision to abandon it. So an officer will typically ask, right after reciting the warnings, whether the suspect understands the rights. Now, omitting asking that question makes proof of an intelligent waiver practically impossible. But intelligent waivers will generally be found where the suspect is asked the question and the suspect affirmatively indicates that he or she understands the rights and goes on to answer the questions. So let's go ahead and say that in this case, the government can show that the waiver was intelligent. Well, we've walked through the particular statement, and questioning is lawful under federal law. Once again, special rules may apply under state constitutions, statutes, or evidence rules, but there do not appear to be any significant barriers to questioning under the U.S. Constitution or federal statutes. Well, that completes our review of the police interrogations tool on trial decks. Hope you'll come by and visit and perhaps look at some of the other tools. This is the first YouTube video we've done for what I suspect will be a trial decks channel, so tune in there as well. Further announcements are likely. Just check on the trial decks blog for developments.